I was still in my robe, sitting at the kitchen table with a cold cup of tea, when the phone rang. The number belonged to Nan, the real estate agent who had known my family since before I could write my own name. She had sold my parents their house 40 years ago. She had brought flowers when my mother passed. When I heard her voice, I expected something ordinary. What she said knocked the air out of me. "Donna, I am so sorry to be the one to tell you this, but your childhood home just sold. The purchase was funded by a transfer from your startup business account." My startup. The one I had spent 3 years building from nothing. The cleaning supply company I had launched with Kyle, my assistant of 4 years. The man I had promoted to junior partner, because I trusted him completely. The house where I grew up. Where my mother baked bread on Sunday mornings and my father taught me to ride a bike on the cracked front sidewalk. Where I still drove past sometimes just to feel connected to something solid and real and mine. Gone. My name is Donna Whitaker. I am 54 years old. I had given everything I had, every late night, every early morning, every dollar I could scrape together, to build something that belonged to me. Before I could find my voice, the back door opened. Kyle walked in with his familiar easy smile, the one I had once found reassuring. Behind him came his mother, Barbara, wearing the particular expression of a woman who has just gotten exactly what she wanted. Kyle held up his phone showing the bank transfer. "It was a smart investment, Donna. The house is in my name now, and Mom thinks it's perfect for gatherings." Barbara patted my shoulder. "Some people just need help managing their dreams, dear," she said. Kyle leaned closer. "There's paperwork you don't even know about yet." The room spun. I had trusted him with the books. I had trusted him with everything. The next afternoon, I drove to the house. The sold sign was planted in the front yard like something final and deliberate. Kyle and Barbara were already there, moving through the rooms with the easy comfort of people who believe an argument is already over. Kyle showed me the bank transfer on his phone, a number that represented months of profit from the startup account I had believed we managed jointly. "It's for the future," he said. "Mom said the house will be great for the family." Barbara was on the front porch drinking coffee from one of my mother's old mugs. She looked at me the way certain people look at someone they have stopped taking seriously. "You've been slowing the business down anyway," she said. I smiled. I nodded. I let them believe the look on my face was defeat rather than calculation. Because in that moment something in me went very quiet and very focused, the way it had the first time I signed a lease for the startup space, and knew I was betting everything on myself. I had learned in those years that panic was expensive and patience was free. Then Barbara dropped a folder of new account statements on the porch table. I picked them up without rushing. The startup account had been restructured. Kyle's name now appeared as primary account holder. My name had been moved to a secondary position that required his authorization for withdrawals above a small threshold. The change had been made 3 weeks earlier. I set the folder down carefully. The house I had loved since childhood was in their hands. The business account I had built was no longer fully mine, and the 2 people responsible were standing in my mother's garden looking satisfied. I said I needed some air and walked to my car. I sat in the driver's seat for 10 minutes. Then I started the engine and began thinking about what came next. That night, I waited until the house was quiet. Kyle and Barbara had gone out for dinner to celebrate, which told me everything I needed to know about how safe they believed they were. I went to my home office and opened the fireproof cabinet where I had kept the original startup documentation since the day we incorporated. The partnership agreement was exactly where I had left it. I read it carefully, though I already knew what it said, because I had written most of it myself. Any expenditure above $5,000 required both partners' written signatures. Any account restructuring required a joint authorization form filed with the bank within 30 days and countersigned by both parties. Kyle had moved the money alone. He had restructured the account alone. My hands were shaking, but underneath the shaking was something steadier. A foundation I had not expected to find. I was still reading when Barbara's voice came through the doorway. "Looking for something, Donna?" She stood in the frame with her arms crossed and her smile very controlled. Kyle told me you might get ideas. We already closed on the house. That part is done. I said nothing. She turned to leave. As she did, I saw the screen of the tablet she was carrying. An email was open. I could not read the full content, but I could see the date in the header clearly from across the room. 3 months before Kyle and I had even registered the startup. 3 months before I had brought him in as junior partner and given him access to the books. The email had been sent 3 months before any of this officially began. They had not made a sudden decision. They had not gotten greedy halfway through and improvised. This had been a plan before it was anything else. I put the partnership agreement back in the cabinet and locked it. Then I went to bed and did not sleep for a long time. The following morning, Kyle announced over coffee that he and Barbara were making a structural change to protect what he called the business future. He used a tone that was meant to sound executive and reasonable, the tone of someone presenting a decision rather than requesting a conversation. The remaining startup funds, the portion not used for the house purchase, were being moved into an account that only he and Barbara could access without restriction. He called it a management account. He said it was for efficiency. Barbara nodded along like this was simply good financial housekeeping. Kyle put his arm around my shoulders and said, "It's for the family, Donna. Don't make this ugly." I nodded. I said that made sense. I asked if he wanted more coffee. But before we had left the office that morning, I had slipped my personal business checkbook into my coat pocket. The old one from the first year of the startup, before we opened the joint account, when everything still ran through my personal business name. A small thing, but mine. At the bank, the teller pulled up the account and looked at her screen for a moment before looking back at me with the particular expression of someone who does not know how much the person in front of them already understands. The restructuring had been completed 17 days earlier. My authorization level had been reclassified without my signature on any document I had seen or signed. I walked out of the bank into the cold air. Then my phone buzzed, an unknown number. A single line of text, "Your assistant isn't the only one who lied to you." I stood on the sidewalk and read the message 3 times. Someone else knew something. Someone connected enough to know my phone number and, distant enough to use an anonymous line, had decided to reach toward me. I saved the number. Then I went to find an attorney. I met attorney Audrey Crane in a quiet coffee shop on the far side of town the next morning. Audrey had done some work for a colleague of mine 2 years earlier and had been recommended specifically because she was thorough, direct, and had no social connection to anyone in the local business community who might know Kyle or Barbara. I had called her the previous evening from my car in the bank parking lot. She read the partnership agreement once, front to back, without speaking. Then she looked at the bank statements. Then she read 3 pages of the account restructuring documentation. She set everything flat on the table and looked at me. "This is embezzlement, Donna. The house purchase used partnership funds without dual authorization as required by your agreement. The account restructuring was done without your consent. Both actions are actionable. We can file to void the purchase and recover the funds." For the first time since Nan's phone call, I felt something other than hollowness. I felt the specific kind of clarity that comes when someone names a thing accurately. On the drive home, Kyle called. His voice was tight and careful, the version he uses when Barbara is nearby and listening. He said her feelings were hurt, that I had left the house without explaining where I was going. He said if I was planning to fight this, Barbara had told him to make it clear they would cut me out of the business completely. Legal fees would consume everything. I would end up with nothing. He said it like he was offering me information rather than making a threat. I thanked him for letting me know and ended the call. Then I pulled over, sat with my hands on the wheel, and took 3 slow breaths. The threat told me they were worried. Worried people make mistakes. I put the car back in drive. Kyle was waiting in the startup office when I arrived that evening. He had clearly spent time preparing the conversation. The tone, the sequence of points, the way he positioned himself near the window so the light was behind him, and his face was harder to read. Barbara sat off to the side like she was simply present by coincidence, though nothing Barbara did was by coincidence. Kyle told me to sign a release he slid across the desk. In exchange, I would receive what he called a fair share, an amount he did not specify but implied was generous. If I refused and pursued the legal route, the real estate transaction would fall through, the business disruption would be extensive, and by the time any court process concluded, there would be nothing left worth having. He said it like he was doing me a favor by offering an exit. I told him I needed to sleep on it. Alone in the office after they left, I opened the old computer, the original desktop from the startup's first month, the one Kyle had stopped using when we upgraded the equipment. It was still logged into his old email account. I had not planned to look, but the folder was right there, labeled simply House. Inside were emails between Kyle, Barbara, and a contact at the real estate firm. The timestamps ran back 8 months. 8 months ago, I had been training Kyle on our accounting system. 8 months ago, I had been explaining our profit-sharing structure and walking him through the partnership documents I had written to protect both of us. The final email in the chain was from Barbara. It said, "Make sure Donna never hears about the house until the money is gone and the deed is signed." I sat in the dark office for a long moment. Then I found a thumb drive in the desk drawer and started copying files. I was at Audrey's office before 8 the next morning. I spread the thumb drive contents across her conference table alongside the original partnership agreement and the bank documentation. She read through the emails in order of date, making occasional notes in the small spiral book she carried everywhere. When she finished, she set her pen down. "This is premeditation," she said. "They planned this before Kyle joined the business. We amend the complaint to add fraud alongside the embezzlement charge. The emails establish intent going back 8 months." She looked at me directly. "This becomes a more serious case than a simple partnership dispute. Are you ready for that?" I said yes. That same evening, while I was in the apartment I had rented temporarily to create some distance from the situation, there was a knock at the door. When I opened it, Kyle's wife Petra was standing in the hallway. Petra and I had always gotten along in the careful way of two people who share someone important and know better than to discuss it too directly. She had kind eyes, and she looked like she had been crying for a while before she decided to knock. She said she hadn't wanted it to go this far. She started to say something else, something that sounded like it was going to be specific and useful. And then Barbara's voice called from somewhere down the hallway, and Petra went still. "Just think about the business," she whispered. The door clicked shut. I stood in the hallway of my rented apartment and thought about Petra's face in the moment before Barbara's voice cut through everything. She had more to say. The situation wasn't letting her say it yet. I put the thumb drive in the inside pocket of my coat where I had been keeping it and went back inside. The lawsuit was filed the following Monday. Audrey moved efficiently once we had the complete evidentiary picture. The complaint named Kyle as primary defendant on the embezzlement and fraud claims, and named Barbara as co-defendant on the fraud claims, given the documented planning emails that predated Kyle's employment with the startup. I was in the temporary apartment when the process server went to the startup office. Audrey had arranged for me to receive a call within minutes of service being completed. When my phone rang, she said simply, "Done." Kyle's face, according to the colleague who happened to be passing the building when the server arrived, went a color that had nothing to do with a tan. Barbara's voice, audible from across the parking lot, reached a register that the same colleague described as genuinely alarming. I sat in my rental apartment and listened to Audrey describe the scene. Then she said the real estate company had contacted her office within 2 hours of the lawsuit being filed. Their general counsel had questions. They had not been informed of any ownership conflict when the purchase was being processed, and they were concerned about their position in a transaction now under active legal dispute. "This is the opening we needed," Audrey said. "If the real estate company cooperates with Discovery, we get documentation from their side of the transaction. Kyle and Barbara's version of events becomes much harder to sustain." I wrote down the date and time of the call. I had started keeping a running log of every significant development, Dates, times, names, who said what, and when, and in what tone. Bookkeepers keep records. The habit had served me well for 30 years in business, and I had no intention of abandoning it at the moment it mattered most. The fight was real now. And real fights have paper trails. The mediation session happened 10 days after the lawsuit was filed, in a conference room at the real estate company's attorney's office. Kyle arrived with Barbara beside him and a lawyer who kept straightening his jacket. Audrey and I arrived 5 minutes early and arranged the documents before they came in. Kyle tried, in the first 20 minutes, to establish the kind of easy rapport with the real estate attorneys that he was good at creating in rooms where no one yet knew him. He smiled and spoke about the business in terms that made it sound like he had built it largely alone and was simply sorting out a misunderstanding with a difficult older partner. Barbara reinforced this version by nodding at specific moments. I slid the email folder to the lead attorney on the real estate side without comment. He read 3 emails. Then he turned to Kyle. We were not informed of any ownership conflict at the time this transaction was processed. He said it in the flat tone of someone who has just understood that a pleasant situation has become an unpleasant one. Kyle stammered. The seller's representative on the other side of the table leaned back. For the first time in any room with the two of them, I watched Kyle and Barbara look small. Genuinely small. The way people look when the story they have been performing meets a room that already has the actual documents. On the drive home, Kyle sent me a text. Barbara is moving more funds out tonight. Stop pushing before there's nothing left to recover. I forwarded it to Audrey immediately and added it to the running log with the exact time and wording. Then I called her and described what had happened, and we spent 2 hours that evening drafting the emergency injunction request. I did not sleep well, but by morning the paperwork was complete. I woke the next morning to a message from Audrey telling me to call immediately. Kyle had made another transfer during the night. A significant amount moved from the restructured account into what the bank records showed as a personal account in Barbara's name. The startup's remaining working capital was now at a level that could not sustain normal operations beyond a few weeks. Audrey met me at the courthouse steps at 9 in the morning. The emergency injunction request had been prepared overnight. We presented it with the intimidation text, the documented overnight transfer, the timing relative to the lawsuit filing, and the original partnership agreement prohibiting unilateral account transactions. The judge granted the injunction within 4 hours. Every account connected to the startup was frozen, pending the resolution of the litigation. Every asset Kyle and Barbara had touched that could be traced to startup funds was subject to the order. Barbara arrived in the courthouse hallway as we were leaving. She had apparently filed something of her own that morning and found our injunction already in place when she arrived. She said, loudly enough for everyone in the hall to hear, that I was a bitter older woman who had always resented Kyle's talent and had manufactured a legal dispute to destroy a business I could not run on my own. I looked at her. I thought about the email dated 3 months before the startup existed. I did not say anything. Behind her, near the elevator, Petra was standing with her coat still buttoned. She looked at me for a moment. Then she mouthed 2 words I could read clearly. I'm sorry. The injunction held. I drove home from the courthouse and sat at the kitchen table in my rental apartment and made a list of everything I still needed to document. The list had 12 items. I crossed off 2 of them that evening and went to bed, knowing that nothing in the accounts could move until a judge said otherwise. Nothing moved. Discovery began 3 weeks after the injunction, and the picture that emerged was bigger than I had originally understood. Audrey's subpoenas reached the startup's full banking history, going back to the first month of operation. What came back showed a pattern of small transfers, amounts between $300 and $800, moving from the startup account to a personal account in Kyle's name on a near-monthly basis. These were not the large transaction that funded the house purchase. They were older, quieter. They had been running for most of the partnership. The audit the judge ordered confirmed the full amount. In the deposition room, Kyle answered questions about the transfers, with the careful vagueness of someone who has been coached extensively and is trying to stay within the coaching. He asked for water. He asked to confer with counsel. He moved his chair slightly every time a specific date was mentioned. Barbara's emails produced through Discovery included one that referred to me as the old burden in a message to Kyle written 14 months earlier, 2 months after the startup launched. The judge reviewed the audit findings at the end of the deposition session and ordered expanded discovery with a criminal referral flag added to the file. That evening, Barbara called me. It was the first time her voice had contained anything other than certainty. The certainty was gone. What remained sounded thin and tired in a way I recognized, the sound of a person who has been walking on solid ground and has just noticed the ground is moving. She said we could still fix everything as family. I listened to her until she stopped talking. Then I hung up. My hands were steady. I had spent the day in a deposition room watching someone be asked questions under oath about decisions he had made while I was training him to read our accounting software. And I had not looked away from a single answer. I was not done. Petra came to my rental apartment on a Tuesday evening, 2 weeks into the discovery phase. She knocked quietly, which was different from Kyle's knock, and when I opened the door she was carrying a small bag and wearing the expression of someone who has made a decision that cost them something significant. She sat at my kitchen table and told me the full history. Barbara had noticed the childhood home come on the market 11 months ago. She had seen the address in the listing and recognized it from a conversation she and Kyle had had with me early in our partnership, when I had mentioned the house during a discussion about what the startup meant to me and why I had put everything into it. Barbara had decided then that owning that particular house would be useful, that it would demonstrate a kind of arrival she had always wanted. She had spent the following months working Kyle into position to execute the plan. Petra said Kyle had hesitated at various points. Barbara had found ways through each hesitation. She slid a flash drive across the table. More records. Text message exports between Kyle and Barbara over the course of the planning period. Specific conversations about timing, about which of my signatures could be managed and which could not, about the forgery they had already been considering. I took the drive. I said thank you and meant it fully. Then Kyle's fist hit the apartment door 3 times. Petra. Now. She squeezed my hand before she went. The next morning, Audrey called to tell me the real estate company was threatening to file a motion to dismiss their involvement unless we reached a settlement quickly. Their position was becoming commercially untenable. I chose to keep pushing. The real estate company's discomfort with the situation was actually useful to us. It created pressure on Kyle's side of the case that we had not been able to generate through the litigation alone. Audrey understood this, and so did I. The third formal hearing was the one where the shape of things began to shift permanently. Kyle's attorney called him to testify and allowed him to state under oath that I had verbally approved the house purchase in a conversation he claimed took place in the startup office on a specific Tuesday 6 weeks before the transaction. He said I had told him to find a good investment for the surplus capital and that he had understood the house to fall within that authorization. My accountant, Walter Briggs, a man I had worked with for 9 years who kept records the way accountants keep records, meaning completely and in triplicate, testified about the startup's financial history. He walked the court through the monthly small transfers that had been identified in discovery, the date the account restructuring had occurred, and the total amount of funds moved without dual authorization as required by the partnership agreement. He had brought original ledger printouts with dates and amounts highlighted. The judge examined them for several minutes. Barbara tried to speak twice during Walter's testimony. She was warned both times to remain quiet. The judge scheduled the final hearing for 4 weeks out and ended the session. Kyle fell into step beside me as I walked out of the courtroom. He kept his voice low and close to my ear. "You will not see the house or the business if you keep this going. I am telling you right now, there will be nothing left when this ends." I looked at him for one moment. Then I kept walking. Outside on the courthouse steps, I stood for a moment in the cold air and thought about the 9 years I had worked with Walter Briggs and the fact that his records were meticulous enough to hold up in a courtroom. I thought about the monthly transfers Kyle had run, small enough to miss in the day-to-day, but impossible to ignore when laid out in sequence across a full audit. Then I walked to my car and drove back to the office. The final hearing took place on a Thursday morning in early spring. Audrey presented everything in sequence. The planning emails going back 8 months before the startup launched, the monthly transfer pattern identified in discovery, the account restructuring documentation, the house purchase transaction, and the text message Kyle had sent during active litigation warning me to stop pushing while Barbara moved funds. Kyle's attorney tried to reframe the case as a family business dispute that had escalated due to miscommunication and differing interpretations of an informal partnership arrangement. He used the word misunderstanding several times with diminishing effect. Barbara sat at the defense table and watched the proceedings with the expression of a woman concentrating very hard on maintaining a controlled appearance. Then the real estate company's attorney rose and announced that his client was formally withdrawing from the transaction. They had determined, following their own internal review of the purchase documentation, that the transaction had been funded by business assets that were now subject to contested ownership. Their client would not complete a sale that was the subject of active fraud litigation. A sound moved through the room. The house purchase was voided. Kyle's face went through several expressions in quick succession. Barbara's face went very still. Then, for just a moment, I saw her smile, a small, private thing directed at no one. She still had a card. She had been holding it the entire time, and she had calculated that losing the house purchase was manageable as long as the card worked. I watched her face and understood that we were not finished, but the house was no longer in Kyle's name. That was real. And it was in the record, and it could not be undone by whatever card Barbara had been holding. The purchase was voided. The original listing would resume, and whatever move she made next would have to contend with a case file that already contained the planning emails, the forgery, and the unauthorized transfers. 2 days after the ruling, Barbara's attorney filed a surprise motion. It claimed I had signed a power of attorney document 6 weeks before the house purchase, granting Kyle authority to make financial decisions on behalf of the partnership without requiring my co-signature. The document was included with the motion. It had my name at the top and what appeared to be my signature at the bottom. Audrey called me the moment it arrived. "Where were you 6 weeks before the purchase?" she asked. I pulled up my calendar. "On a supply run," I said. 3 days in the northern part of the state visiting 4 distributors. I have receipts, hotel records, and emails sent from the road the entire time." "Good," she said. "That's exactly what I needed to hear. We're requesting forensic handwriting analysis and filing a motion to strike the document pending the analysis. Someone signed that paper, and it wasn't you." The analysis request was filed the same afternoon. While we waited for the analyst's report, Kyle's lawyer sent 2 settlement proposals. Both offered me full return of the startup and a reduced damages figure in exchange for dropping all claims against Barbara personally. Both were declined. During that same waiting period, Petra called me from a number I had not seen before. She spoke quietly and quickly. She said Barbara had practiced the signature. She had watched her do it at the kitchen table one evening, using a copy of my original signature from a lease document Barbara had photographed without my knowledge. Barbara had tried it 4 times on scratch paper before she was satisfied with the result. I told Audrey the same evening. Petra's statement was added to the evidentiary record. When Audrey told me she had it formally documented, she also told me what it meant for the forensic analysis, that we now had a witness who had been physically present when the signature was practiced, which was a different category of evidence from the analysis alone. The forensic handwriting expert testified the following week in open court. She was a methodical woman who had been doing document analysis for 23 years, and who explained her findings with the patience of someone accustomed to making precise conclusions accessible to a non-specialist audience. She used enlarged side-by-side comparisons projected on a screen. My authentic signature drawn from a notarized business document predating the startup, the power of attorney signature, and a document recovered during discovery from Barbara's home files. The third document was one of the practice sheets Petra had described. The expert walked through the comparison point by point. The pressure distribution was inconsistent with my writing pattern. The angle of the letters deviated from my established formation. The micropauses visible in the forgery, places where the pen slowed while the writer's hand tried to remember what came next, did not appear in any authentic sample of my signature. Kyle looked at the projected comparison, and then looked at the table in front of him. Barbara had been composed through the opening testimony. She had been composed through the first comparison chart. When the expert confirmed that the practice sheet and the power of attorney showed identical formation errors, Barbara's composure left her face completely and very quickly. I watched it go. The judge's ruling came within minutes of the expert finishing her testimony. The power of attorney was voided as a forged document. The fraud findings were expanded, full damages were ordered. The forgery finding was referred to the district attorney for potential criminal proceedings. I walked out of the courthouse and stood in the spring air for a long moment. The house purchase had been voided at the previous hearing. The full monetary judgment was confirmed. The fraud and forgery were now formally on the record, referred for potential criminal proceedings, and impossible to paper over with a settlement offer. Everything they had built was coming undone in order. The financial recovery process began within 30 days of the ruling. The court order was specific and enforceable. Every dollar transferred from the startup account without proper dual authorization, the house purchase funds, the monthly smaller transfers identified in discovery, the overnight account movement during active litigation, was subject to return with interest calculated at the statutory rate from the date of each unauthorized transaction. The startup's accounts were unfrozen. My name was restored as primary account holder. The account restructuring Kyle had executed without my authorization was reversed by court order. I thought the main fight was over. I was in the startup office late one evening reviewing the restored accounts when the certified letter arrived in the next morning's mail. Barbara was filing for Chapter 7 bankruptcy protection. The filing listed her primary assets, claimed limited liquid resources available to satisfy the damages judgment, and sought protection that would allow her to discharge the civil debt through a trustee-managed process. If bankruptcy protection was granted, her personal assets, including the portion of the down payment that had already been transferred to her name during the transaction process, could be shielded from the judgment. The fight was not finished. I called Audrey from the startup office that evening, standing among the equipment and inventory I had spent years building. "I filed our response this morning when I saw it come through the court system," she said. "Using bankruptcy to discharge a debt arising from intentional fraud has its own complications. The trustee will see the full case history." I told her I understood. I stood in the startup office for a long time after I hung up. I had been in this space every working day for 3 years. I knew which shelf had the weak bracket, which window stuck in cold weather, which supplier required a call rather than an email when an order was urgent. It was mine. It had always been mine. I went back to the inventory. Bankruptcy court operated at a different pace and with different rules, but the underlying shape of things was familiar. Their version of events, then the documents that told the accurate story. Barbara's attorney presented a sympathetic account of her financial situation. Investment losses over several years, rising personal expenses, the genuine difficulty of a fixed-income retirement in an economy that had not cooperated with her planning. He framed the bankruptcy as a reasonable response to circumstances rather than a maneuver. Barbara took the stand on the second day. Her attorney walked her carefully through a prepared account that acknowledged the judgment, but presented her role in the underlying events as peripheral and reactive rather than central and planned. She said she had supported Kyle in a business decision she believed was legitimate. She said she had not known the partnership agreement required dual signatures. Audrey cross-examined her about the emails, about the planning timeline, about the overnight transfer during active litigation, about the text messages Petra had provided through the discovery process. Barbara's answers became shorter with each question. The bankruptcy trustee, a methodical woman who had read the entire case file before the proceeding began, looked at Barbara from across the room when Audrey finished and said, without particular emotion, "This appears to be an attempt to use bankruptcy protection to discharge a judgment arising from deliberate fraud." Barbara began crying on the stand. I watched her and felt something that was not satisfaction. It was simpler than that. It was just the experience of watching a true account replace a false one in an official room. Kyle was still contesting every line of the damages calculation through his own separate filings, which was producing legal fees on both sides and gaining him very little ground given the evidentiary record. But the trustee had read the documents. That was what mattered most in that room. Kyle's attorney contacted Audrey with a settlement proposal 3 weeks into the bankruptcy proceedings. The offer was structured this way: I could keep the startup in full and receive 60% of the calculated damages if I agreed to drop all remaining personal claims against Barbara. Her bankruptcy would proceed, the civil judgment against her would be discharged through the trustee process, and both sides would walk away from any further litigation. Audrey presented it to me in her conference room and gave me room to read it twice. I turned the document over. 60% of the damages and full control of the startup sounded like a reasonable outcome if you did not know the whole history. But dropping all personal claims against Barbara meant the district attorney referral lost its strongest supporting complainant. It meant the forgery charges stayed civil. It meant the person who had planned this 14 months before it happened, who had written an email telling Kyle to make sure I never found out until the money was gone, would pay a financial penalty and walk away from everything else. The offer was designed to protect Barbara. I said no. That night, Kyle came to the startup office. He knocked at the side door after hours and stood in the doorway looking like someone who had run out of other options. He talked about mounting legal bills, about the bankruptcy consuming what remained. He asked me to consider the full human cost of what continuing meant for everyone involved. I listened to everything he said without interrupting. Then I told him the door was closing and I needed to lock up. He stood there for a moment with his hands in his pockets, and I recognized the look. It was the same one he had worn the morning I first showed him our accounting system and told him I was trusting him with something I had built from nothing. He had seemed grateful then. He left. The bankruptcy trustee issued her ruling 4 weeks after the hearing. The ruling was detailed and specific. It found that the timing and structure of the filing, its proximity to the civil judgment, the pattern of asset transfers prior to filing, the evidence of intentional conduct in the underlying case was consistent with bad faith use of bankruptcy protection rather than genuine financial emergency. Bankruptcy protection was denied. The damages judgment stood in full. The portion of the down payment that had been transferred to Barbara's personal accounts was subject to recovery under the civil judgment. I was in the gallery when the ruling was read into the record. Barbara sat at the defense table with her hands folded and her posture very controlled, the posture of someone maintaining form because form is the last available resource. When the ruling was announced, she did not move for several seconds. Then she turned and looked across the room and found me. I had spent a significant amount of time over the preceding months thinking about what her face would show in this moment. I had imagined several versions. What I saw was fear, not the performed vulnerability she had shown on the stand. Something real and unmanaged. Petra was sitting 1 row ahead of me in the gallery. She reached back without looking and took my hand. She said quietly, "She built every part of this, Donna. You just made sure it couldn't stand." I held her hand and looked at the front of the room. Outside the courthouse, for the first time since Nan's phone call, the air felt like it was moving normally. I stood on the steps for a moment and thought about the day I had driven to the childhood home and seen the sold sign in the front yard. I thought about what it had taken to get from that afternoon to this one. Then I walked to my car. The startup office reopened for full operations on a Monday morning in early summer. I had spent the 3 weeks before the reopening working quietly and without announcement, restoring supplier relationships, fulfilling the smaller orders that had survived the disruption, and rebuilding the inventory to a level that could support normal operations. 2 employees who had left during the legal period came back when I called. Both said yes the same day. I had also, during the quieter moments of the legal period, been building something new. The startup's original product line was solid, but there was a segment of the commercial cleaning market I had been meaning to approach for 2 years and had never found time for. I had used the enforced downtime to research it properly and had secured 3 new commercial accounts before the office formally reopened. Kyle came in on the second day. He was not wearing the easy smile. He stood just inside the door and looked at the restocked shelves, the 2 employees moving in the back, the order clipboard on the counter. He said they were losing everything. The legal fees, the bankruptcy denial, the judgment. He asked how I had managed to rebuild during the legal fight. I said I had stayed focused on the work. He looked at the commercial accounts clipboard for a moment. He said, "You started over without us." It was not quite a question. I said yes. He stood there for another moment. Then he left without saying anything further. I stood at the counter for a moment after the door closed. 4 years of working beside that man. I had trained him, trusted him, promoted him to junior partner, because I believed the work had earned it. That history was real. It did not outweigh what was in the planning emails or on the bank records. But it was real. I went back to the order I had been working on before he came in. Barbara came to the startup office 8 days after Kyle. She arrived in the late afternoon when the employees had gone and the front room was quiet. She was wearing clothes I did not recognize. Simpler than anything from the Barbara I had known, older and less deliberate. She looked at the office the way people look at a place they had expected to belong to them. She stood at the counter. Then she said, "I was only trying to protect my son." I let the sentence settle without filling the space it left behind. I thought about the email she had sent 8 months before the startup launched. I thought about make sure Donna never hears about the house until the money is gone. I thought about the signature practiced 4 times on scratch paper at her kitchen table. I reached under the counter and slid the final court order across to her. It was the damages repayment schedule. Specific amounts, specific dates, the complete accounting of what was owed and by when. She read it. She read it again. Then she looked up. "Please, Donna. We genuinely have nowhere left to go." I had thought about this moment in the same way I had thought about Barbara in the gallery. In advance, in several versions, trying to anticipate what it would actually feel like. What it felt like was quieter than I had expected. I said, "The schedule stands. Audrey's office will be in contact on each due date with confirmation requirements." I said it without raising my voice and without changing my expression. The schedule was in the court order. It did not require my tone to enforce it. Then I said that the office was closing and I needed to lock up. She left. I locked the door and stood in the empty office for a moment. Then I turned the lights off and went home. June arrived and the startup was generating its best monthly revenue since we had launched. The commercial accounts I had built during the legal period were now producing consistent income, and I had identified 2 additional prospects in an adjacent market segment that Audrey estimated could be secured within the quarter. The employees were working regular hours. The supplier relationships were stable. The books, which I had taken back over completely and now maintained with the personal attention I had given them before Kyle, were clean and straightforward, and mine. Barbara and Kyle were living in a 2-bedroom rental across town. Petra had moved out 3 months earlier, which had not surprised me when I heard it, and which I did not allow myself to feel anything complicated about. The childhood home had been relisted after the voiding of the sale. The listing appeared in my email one morning from Nan, who had been keeping track of the property on my behalf since the lawsuit began. She sent it with a short note that said simply, "It's back. Let me know." I read the listing description. The house was exactly as I remembered it in the essential ways. Same footprint, same front sidewalk where my father had run alongside me while I learned to balance. The interior had been updated at some point in the last decade, which I had expected. I called Nan that evening. I asked her to put together the offer documentation. I was in a stronger financial position than I had been at any point in the previous year. The damages repayment schedule was producing monthly returns. The startup's revenue was growing. The legal costs were behind me. I said I was ready, and I meant it in a way that was different from the readiness I had needed for the legal fight. This was the simpler readiness of someone who knows what they want and has the means to pursue it. Nan said she would have the paperwork ready by Friday. Kyle called at midnight, 6 weeks after Barbara had come to the office. His voice had lost the last of the versions I had known. Not the easy smile version, not the threatening version, not the careful coached version from the depositions. What remained was just a person who had been running at full capacity for a long time and had arrived at a stop. He said Barbara was in the hospital. Chest pains, he said, brought on by the sustained stress of the legal period and the financial pressure of the repayment schedule. The hospital bills were generating quickly, and the legal fees had consumed what remained of their accessible funds. He said they had no options left. I listened to him talk. He said some things that were designed to produce guilt, and some things that were simply the accurate description of a difficult situation. I did not try to sort them into categories while he was talking. When he finished, I said I would cover Barbara's medical bills. He went quiet for a moment, in a way that told me he had not expected that. Then I told him the terms. Both of them, Kyle and Barbara, in person, in Audrey's office, were required to sign a permanent release, full and unconditional acknowledgement that the startup and all its assets belonged to me, full and unconditional waiver of any future claim they might attempt to bring. No exceptions, no carve-outs, no revisitation. A clean document that closed every remaining door. No further moves, no further games. Kyle called back at 7 the following morning. He said yes. I called Audrey and asked her to prepare the complete release documentation. Then I called the hospital billing office and arranged payment before a single thing had been signed, because that was who I was and what had been done to me had not changed it. They came to Audrey's office the following morning at 9 o'clock. Kyle wore something that looked like it had been borrowed. Barbara came in a cardigan I had not seen on her before. Older and simpler than the Barbara who had stood on my mother's porch, drinking from one of her mugs and telling me I had been slowing the business down. They sat across the conference table from Audrey and me, with their hands in their laps and their eyes on the documents in front of them. Audrey walked through every page without rushing. The full scope of the release. The permanence of each clause. The complete and irrevocable nature of what they were signing. Neither of them spoke. Barbara picked up the pen first. She signed slowly and carefully. Mark signed after her. Audrey witnessed and notarized both signatures. I took the hospital bill payment confirmation from my purse and placed it on the table in front of Barbara. She looked at it for a moment. Then she picked it up. She did not say thank you. I had not written the check expecting gratitude. I had written it because I told Kyle I would, and because keeping my word had never required the other person to deserve it. They left without looking back. I stayed in Audrey's conference room for a few minutes. The room was very quiet. Outside the window, the summer morning looked uncomplicated and bright. Then I drove to the childhood home. Nan met me in the front yard with the signed acceptance paperwork. The offer had been accepted the previous afternoon. I stood on the front sidewalk, the cracked section where my father had run beside me, and let go without telling me he was letting go, and held the papers in both hands. I, Donna Whitaker, had taken back my life, legally, patiently, and completely. That night, sleeping in a hotel 2 blocks from the house that would be mine within 30 days, I slept without a single nightmare. If this story hit you somewhere deep, if you've ever been underestimated by the people who were supposed to protect you, or if you know what it feels like to have your voice taken away by someone who smiled while they did it, then you already know why Brooke's story matters. This is the kind of story we tell here. Real stakes, real consequences, real people who refuse to fold. Subscribe and turn on the notification bell so you never miss the next one. Because the stories coming are even more powerful than this one, and you don't want to be the last person to hear them. And before you go, drop a comment and tell me, where are you watching from? And what part of Brooke's story hit you the hardest? Share this with someone who needs to hear that staying quiet can be the most powerful move you make, and that the truth always finds its way to the surface, no matter how deep someone tries to bury it. We'll see you in the next one.